Let all laws be clear, uniform and precise, as said by Voltaire. Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. We will learn about the legal history and application of the Uniform Civil Code today, which happens to be an extremely contentious topic. The objectives of the present module are to understand the history and significance of the Uniform Civil Code, to talk about the purpose and reach of India's personal laws, and to investigate the Uniform Civil Code's constitutional mandate. Then, to highlight the arguments for and against the Uniform Civil Code's implementation, to review the significant court rulings pertaining to the issue, to put forth some suggestions for the Uniform Civil Code's effective implementation. Let's begin with the introduction. India, as envisaged in the preamble to the Constitution of India, is a secular nation. In our country, there is a diversity of religions, castes, tribes and languages. India is a secular state with different personal laws for different religious groups. Here, people belonging to various religious groups exist: Hindus, Muslims, Sikhs, Jains, Buddhists, Parsis, Jews and Christians. Hindus, Sikhs, Jains and Buddhists are governed by Hindu law. Muslims are governed by Sharia and Christians, Parsis and Jews by their own personal laws. There is no unified civil code governing the issues of marriage, divorce, maintenance, adoption, custody of children and inheritance, etc. However, other set of laws, namely criminal law, law of contract, transfer of property, taxation, have uniform application to all the citizens of India, irrespective of their religion. Despite calls for a uniform civil code from the time of the drafting of the Constitution, personal laws have largely been left untouched by most of the governments in power. Here, it is important to understand the meaning and scope of personal laws. Personal laws are a set of laws that apply to a certain class or a group of people or a particular person based on religion, faith and culture. In India, personal laws guided by religion are applicable in the civil realm, which covers aspects like marriage, divorce, guardianship, adoption and succession. These are broadly characterized as family laws. Religious and tribal identity determines which set of personal laws an Indian is governed by. Like, Hindus are governed by 4 laws passed by India's parliament in the 1950s, which constitute the Hindu Code. These laws are the culmination of a political movement to codify and modernize Hindu law, granting women important rights denied under the customary Hindu law. Similarly, Muslims in India are governed by Sharia law in matters of personal law, as acknowledged by the Shariat Act 1937. Dear learners, let's discuss about what the Uniform Civil Code means. Uniform Civil Code is a term originating from the concept of a civil law code. The term civil code is used to cover the entire body of laws governing rights relating to property, personal matters like marriage, divorce, maintenance, adoption and inheritance. The Uniform Civil Code is administering one set of secular laws to govern different people belonging to different religions and regions. The idea of Uniform Civil Code is guided by the principle one citizen, one nation, one code. The basic principle is that people similarly situated geographically and culturally should be treated equally before the law. Now, let's review the historical context. Personal laws were first framed during the British Raj, mainly for the Hindu and Muslim citizens. The British feared opposition from community leaders and refrained from further interfering within this domestic sphere. The demand for a uniform civil code was first put forward by women activists in the beginning of the 20th century, with the objective of women's rights, equality, and secularism. Till independence in 1947, a few law reforms were passed to improve the condition of women, especially Hindu widows. In 1956, the Indian Parliament passed Hindu Code Bill, among significant opposition. The debate for a uniform civil code dates back to the colonial period in India. The Lex Loci report of October 1840 emphasized the importance and necessity of uniformity in codification of Indian laws relating to crimes, evidence, and contract, but it recommended that personal laws of Hindus and Muslims should kept outside such codification. According to their understanding of the religious divisions in India, the British separated this sphere, which would be governed by religious scriptures and customs of the various communities like Hindus, Muslims, Christians, Parsis, etc. What is the subject matter's constitutional mandate? Uniform Civil Code is a mandate addressed to the state by Article 44 of the Constitution, the highest law of the land. It provides that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. The basic purpose of Article 44 is to bring uniformity in personal laws relating to marriage, divorce, succession, inheritance, and like matters. Thus, the idea behind incorporating this provision in the Constitution is to convert a heterogeneous society into a homogeneous one, which is essential for unity, integrity, and solidarity of the nation. After 75 years of independence, the Uniform Civil Code seems imperative, as the articles in the Constitution are directives with mandate and not merely messages or instructions. Even Dr. B.R. Ambedkar and other members of the Constituent Assembly must not have meant by reckoning to make Article 44 and other articles of Chapter 4th of the Constitution to merely remain as ornamental provisions without any implementation initiative. Uniform Civil Code is a binding obligation under international law. Under international law, a state that ratifies an international instrument becomes legally bound to implement its provisions. Accordingly, India, having ratified the International Covenant on Civil and Political Rights 1966 and International Convention on the Elimination of All Forms of Discrimination Against Women, that is CEDAW 1979, is bound to enforce the relevant provisions and ensure gender equality under national laws. However, women in India under Hindu, Muslim, and Christian laws continue to suffer discrimination and inequalities in the matters of marriage, succession, divorce, and inheritance. So, as a step towards a gender just code, the personal laws of various communities in India need a closer look and reform, not only in the compliance with the Indian Constitution, but also as per the provisions of the international law. Dear learners, let's examine the arguments concerning the Uniform Civil Code. Uniform Civil Code is a term originating from the concept of a civil law code. The term civil code is used to cover the entire body of laws governing rights relating to property, personal matters like marriage, divorce, maintenance, adoption, and inheritance. The Uniform Civil Code is administering one set of secular laws to govern different people belonging to different religions and regions. As said earlier also, the idea of Uniform Civil Code is guided by the principle one citizen, one nation, one code. The basic principle is that the people similarly situated geographically and culturally should be treated equally before the law. Recently, the 22nd Law Commission of India issued a public notice seeking comments on the Uniform Civil Code. This came as a surprise, given the 21st Law Commission, after many months of public discussion, concluded that a Uniform Civil Code was neither necessary nor desirable at this stage. The 22nd Law Commission's primary justification for the re-examination was that more than 3 years had passed since the previous report. There is also demand for a Uniform Civil Code from certain sections of women's rights movement in India since the 1930s. Yet, there remains a void at the heart of this debate due to a lack of detail. No one quite knows what Uniform Civil Code would look like and how it would address the complex political and constitutional issues concerning personal laws in India. Dear learners, as far as the arguments against Uniform Civil Code are concerned, the spine of controversy revolving around the Uniform Civil Code has been secularism and the freedom of religion mentioned in the Constitution of India. The preamble of the Constitution states that India is a secular democratic republic. This means that there is no state religion. A secular state shall not discriminate against anyone on the ground of religion. A state is only concerned with the relation between man and man. It is not concerned with the relation of a man with God. It doesn't mean allowing all religions to be practiced. It means that religion should not interfere with the mundane life of an individual. In S.R. Bommai versus Union of India, a judgment of 1994, as per Justice Jeevan Reddy, it was held that religion is a matter of individual faith and cannot be mixed with secular activities. Secular activities can be regulated by the state by enacting a law. The Uniform Civil Code is not opposed to secularism or will not violate Article 25 and 26. Article 44 is based on the concept that there is no necessary connection between religion and personal law in a civilized society. Marriage, succession, and like matters are of secular nature and therefore law can regulate them. According to Muslim thinkers, their personal law is divine and as such a direct descendant from the Quran, and hence it is immutable and untouchable by the legislature. The controversy first erupted in the Constituent Assembly when draft Article 35 was debated. After the full debate, the Constituent Assembly rejected the contention that personal law flows from religion directly. On the other hand, the Constituent Assembly has retreated its conclusion that all other laws, personal laws, are also secular. The Uniform Civil Code will not and shall not result in interference of one's religious beliefs relating mainly to maintenance, succession, and inheritance. One thing is clear, that the Uniform Civil Code is a divisive issue in India, with proponents arguing that it would promote equality and secularism, and opponents arguing that it would interfere with religious freedoms and cultural practices. Overall, the debate over the Uniform Civil Code in India highlights the complex and sensitive relationship between law, religion, and culture in the country that should be scrutinized from the detached point of view and should be addressed in a phased and holistic manner. Article 44 rests on the premise that in a civilized society, there is no direct connection between religion and personal laws. Religious freedom is guaranteed by Article 25, while Article 44 separates religion from social relations and personal laws. The constitution makers believed that while marriage, succession, and like matters had a sacramental origin in all faiths, yet they are essentially secular matters and cannot be brought within the guarantees enshrined under Article 25, 26, and 27. Another argument which is advanced in favor of the Uniform Civil Code is that with the enactment of a Uniform Civil Code, secularism will be strengthened. Much of the present day separation and divisiveness between the various religious groups in the country will disappear, and India will emerge as a much more cohesive and integrated nation. A Uniform Civil Code is also required to achieve equality and gender justice. Personal laws of all religions discriminate against women on matters of marriage, divorce, inheritance, and so on. There is an urgent need to cull out the just and equitable laws of all religions and form a blueprint for a Uniform Civil Code based on gender justice. A Uniform Civil Code is necessary to curb the gender inequalities prevalent under different personal laws. My dear learners, it's time to look into the judicial response towards the Uniform Civil Code. India's Supreme Court has backed a Uniform Civil Code in religiously diverse India, saying all citizens should be bound by the same marriage, divorce, and property inheritance laws. The State of Bombay versus Narsu Appamalli, a judgment of 1952. It was the first case in which the Bombay High Court favored the introduction of the Uniform Civil Code and held that institution of polygamy was not based on necessity. Then in Shahulu Midu versus Subaida Bibi 1970 and Miss Jordan Dienge versus S.S. Chopra 1985, the Supreme Court again observed that Article 44 of the Constitution was obligatory on the part of Parliament as well as the Judicature. Muhammad Ahmad Khan versus Shah Banu Begum 1985 and Saira Banu versus A.M. Abdul Ghaffur 1987 are yet another two important cases in which the Supreme Court laid down solid foundation for the Uniform Civil Code in spite of Muslim Women Protection of Rights on Divorce Act 1986. In Shah Banu Begum's case, the Constitution Bench of the Supreme Court made an observation that Article 44 of our Constitution had remained a dead letter. There is no evidence of any official activity for framing a common civil code for the country. A common civil code will help the cause of national integration by removing desperate loyalties to laws which have conflicting ideologies. It is a state which is charged with the duty of securing a uniform civil code for the citizens of the country, and unquestionably it has the legislative competence to do so. A beginning has to be made if the constitution is to have any meaning. Interestingly, there was a deviation from the earlier precedents by the Supreme Court in Maharishi-Avdesh case 1994. In the earlier cases, the Supreme Court has emphasized the urgency for enacting a uniform civil code on the part of legislature. But in Maharishi-Avdesh case, the court, while dealing with the petition under Article 32, seeking writ of mandamus to Union of India for considering enactment of Uniform Civil Code and also declaring Muslim Women Protection of Rights on Divorce Act 1986 as ultra vires the Constitution. The bench, comprising Justice Jaya Chandra Reddy and Justice Ray, held that writ is not maintainable. The court opined that as the matters are in legislative sphere, court cannot legislate on these matters. The court did not venture to make any observation about the need for a uniform civil code. Subsequently, in a landmark judgment in Sarla Mudgal versus Union of India 1995, the Supreme Court directed the Prime Minister to take a fresh look at Article 44 of the Constitution, which according to the court is imperative for both protection of the oppressed and promotion of national unity and integrity. In cases like Ahmedabad Women's Action Group versus Union of India 1997, the Supreme Court became a bit reserved and held that matter of removal of gender discrimination in personal laws involves issues of the state policies with which the court will not ordinarily have any concern. The decision was criticized that the apex court had virtually abdicated its role as a sentinel in protecting the principles of equality regarding gender-related issues of personal laws of various communities in our country. The desirability of a uniform civil code can hardly be doubted, but it can be concretized only when the social climate is properly built by the elite of the society, a statement amongst leaders who, instead of gaining personal mileage, rise above and awaken the masses to accept the change. In Lily Thomas versus Union of India 2000, the desirability of a uniform civil code can hardly be doubted was held by the court. But as observed earlier, it can be concretized only when the social climate is properly built up by the elite of the society, statements among leaders who, instead of gaining personal mileage, rise above and awaken the masses to accept the change. Similarly, in Panna Lal Bansi Lal Pitti versus State of Andhra Pradesh 1996, the court pointed out that a uniform law, though is highly desirable, enactment thereof in one go perhaps may be counterproductive to the unity and integrity of the nation. In a democracy governed by rule of law, gradual progressive change and order should be brought about. Even in 2001, the Supreme Court in Daniel Latifi and another versus Union of India upheld the validity of Section 3 and 4 of the Muslim Women Protection of Rights on Divorce Act 1986 as not being violative of Articles 14, 15 and 21 of the Constitution of India. Under Section 3 of the Muslim Women Protection of Rights on Divorce Act 1986, a Muslim husband is liable to make reasonable and fair provisions for the future of a divorced wife, which includes maintenance also. So, she is not entitled to claim maintenance under Section 125 of the CRPC. Under Section 4 of the Act, divorced Muslim women unable to maintain herself after iddat period can proceed against her relatives or Waqf board for maintenance. In the light of the above discussion, now let's conclude the topic with few suggestions. Unification of personal laws in accordance with Article 44 is necessary to achieve the goals of pure secularism, equality, gender justice and patriotism. A beginning has to be made if the Constitution is to have any meaning. The personal laws cannot be above the constitutional laws. The government should prepare a model uniform civil code as early as possible. It should not be based on personal laws of any religion. Rather, it shall be based on gender equality and comprise the best elements of all the personal laws. It is submitted that such a model code should be put to a national debate. Opinions, objections and suggestions of legal luminaries, jurists, academicians and religious leaders should be invited. A national level discussion on the subject of uniform civil code is desirable to remove the fear and apprehension of the minorities that such a common civil code will abridge their personal laws. Last but no way the least, the government in its first step should introduce an optional code instead of a compulsory code for those who may opt for it. In the words of Justice V.R. Krishna Iyer, the time has come for the nation to sit back and draw up a progressive jurisprudence which governs Indian humanity. Otherwise, the communalism, fundamentalism and primitivism will hold the country to ransom. Today, there is an awakening. If we delay, we may fall. I hope you may find this lecture informative. Thank you very much.